Hello and welcome to Law in Brief, brought to you by Legal Eagles LLP. My name is Emma Proud and today I'm joined by Leandro Peixoto, Mark Tamayosa and Alex Ambrosek. Our topic for discussion today is music downloads. Advances in technology such as faster broadband have made it easier for people to access a wide range of music on the internet. We've seen increases of online sales of CDs and downloads of digital media. However, through such means as peer-to-peer file sharing, individuals are now able to make their music available for others to download from them for free. So why is this a legal issue?
Well, the problem with making music available to others across the internet is that copies are made available without the copyright holder's permission.
So what law would apply in terms of uploading and downloading music?
This has been amended over the years, and the current legislation in the UK is the Copyright Design and Patent Act 1988. This is both a public and a private law. A case brought against a person who infringes copyright could be both civil or criminal. As soon as artists create a song in a permanent form, they have copyright of that work and can control the way in which that may be used. This includes making copies available to the public via internet. Copyright in the UK lasts for the lifetime of the creator plus 70 years.
Okay, thank you. So is there any relevant EU law?
The UK law has developed over the years in line with EU directives. Since 1991, there have been 7 EU directives relating to copyright law. The most recent, the Copyright Directive 2001, attempted to harmonize copyright legislation across the EU, particularly in response to changes in digital media and the growth of the internet. The UK implemented the regulations in the form of the Copyright and Related Rights Regulations 2003.
And what were the key changes in relation to music downloading?
The 2003 regulations strengthened the copyright holders' rights, in particular the right to control how their work is communicated and made available to the public, and restricting how people can avoid copyright measures put in place by the music industry. For example, codes on CDs to prevent unlawful copying.
And so how does the judge decide on the ruling?
Well, as well as the Copyright Design and Patent Act 1988 and the EU law, the judge will consider the judgment as were made in other copyright infringement cases relating to the downloading music from the internet. As an example could be Polydor Limited and others against Brown and others 2005. Polydor and other record companies brought a case against 2 individuals who made 8,906 songs available for the other people to download from the internet. This case was a civil dispute, and due to the legal importance of the case, was proceed in the higher court. The judge ordered the 2 men to pay damage to the British phonographic industry between 1,500 and 5,000 in damage.
And how are disputes resolved if a person's copyright is breached?
As the Polydor case shows us, a civil claim can be brought against a person who infringes copyright. If it is a small, straightforward claim, it will be dealt with in the county court, and the defendant might be ordered to pay damage. If the amount of the claim is higher than 15,000, but the case is complex, the case will be sent to the higher court for judgment. However, cases of this nature are often settled out of the court in order to keep the cost down. A company such as Polydor will write to the individuals concerned and explain they wish to bring the case against them for breach of copyright, but are willing to avoid the case going to court if they receive a payment of X amount.
So is it a criminal offence to download music from the internet without paying for it?
Well, Each case is dealt with on its own merit, but in accordance to the new 2003 regulation, it is a criminal offence to work to the public or by take away the performer's making available right. If a criminal case is brought against an individual who has been downloading or making music available on the internet, because the potential prison sentence between 3 months and 2 years and the fine is up to £5,000, the court of first instance would be the magistrates. If it is a summary offence, the case is dealt is judgment in the court. However, the case is complex or of a particular legal importance, then the case would be sent to the Crown Court where the defendant is tried or indictment. This could result in up to 2 years in prison, a fine, or both.
And what actions have been taken so far to cut down on illegal downloads in the UK?
In July 2008, the UK government brokered a memorandum of understanding between 6 leading ISPs and the music and film sectors. It commits all parties to reducing piracy, and in a trial period during October 2008, ISP wrote warning letters to infringing customers. The development of legitimate download sites such as iTunes have embraced the concept of digital downloads in accordance with the artist's rights. Users are able to buy download music from a wide selection of tracks at a small fee. Amazon UK has recently launched a version of this model. Furthermore, sites offering free legal downloads such as Spyrophone in the USA have developed. These sites use peer-to-peer network to make songs available to its users. The sites work in partnership with the record companies to pay their royalties through advertising. The site monitors what songs people are downloading and then calculates how much the artist is owed.
Thank you. And finally, what are the thoughts of our panel on the future for downloading music in the UK?
What are the thoughts of our panel regarding the next steps for music download? Number 10. With the right attitudes, the digital developments could mean an improvement in the way in which artists communicate their works to the public. However, the issue of downloading music without permission from the copyright holder still needs to be resolved. Denmark was the first place to have a permanent disconnection of the internet, working with internet providers if they caught a person uploading or downloading music. Following the UK MOU, we may see stronger ways of enforcement such as this in the future. Nonetheless, an independent review of the copyright law in the UK was conducted from December 2005 to December 2006 by Andrew Gower. The result of the report has shown that he is willing to keep the law as it is, but has a few recommendations, such as private copying exemption should be implemented into the copyright law, the copyright period of 50 years should be maintained and not extended to 95 years as in the United States. He also recommends that the EU directives allows for an exception of a creative, transformative or derivative works, as long as there is no clash between the sample used and the original works.
After every take, we do it a few seconds.
Who's going next time?
I think, who is next? Him, no?
So that's it from me and our guest panel today. We hope you've enjoyed the show and we'll see you next time on Law in Brief. Goodbye.